XRP is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. In the continuing legal struggle between Ripple and the U.S. Securities and Exchange Commission, John Deaton, a major XRP supporter, has shed light on possible conflicts of interest and regulatory capture that may have impacted the SEC's decision to launch legal action against Ripple. Ethereum is at the core of these claims. The elaborate tapestry known as ETH displays a complicated network of connections. The charges are complex and difficult to manage. Deaton summarized the most important elements in a recent tweet. Deaton draws attention to a series of incidents that link former SEC Chairman Jay Clayton and SEC staffer William Hinman. On March 26, 2018, Lowell Ness, a lawyer for a 16s, reportedly handed a message and a safe harbor agreement to Hyman. The paper particularly mentioned ETH. Soon after, Hyman proclaimed ETH to be a non-security, despite the fact that he was not formally retired and was still a profit sharing partner with his law company, which was a member of the Enterprise Ethereum Alliance. According to Deaton, Hyman's law firm was a member of the EE, and Hyman was not retired, but rather a profit-sharing partner with his law firm when he declared ETH a non-security 10 weeks later. Furthermore, Deaton claims an obvious conflict of interest with Clayton's legal firm representing Joseph Lubin, ETH's co-founder, and Consensus, a significant ETH holder and booster. Deaton points out another possible conflict. Clayton's firm also brokered the merger between Quorum and Consensus, using the Jeepin coin, a direct competitor to Ripple and XRP. The participation of Joe Grunfest complicates things even further. According to Deaton, Grunfest was an essential element of the aforementioned working group, and he had communications with Ethereum founders as early as 2015. Deaton quotes Grunfest as saying, "He said XRP should not be treated any differently than ETH." Grunfest suspected the widespread evacuation of Clayton, Hyman, Berger, and others. He said there was no justification to file the complaint since XRP has traded openly for 7 years, and that innocent people with no connection to Ripple would suffer the most. Despite the appeals, Clayton decided to sue Ripple on his way out of the SEC. Clayton soon joined One River, which had already put a $1 billion wager on Bitcoin and Ethereum. Returning to Hyman, Deaton notes that Hyman returned to his e-law firm $15 million richer after less than 3 years at the SEC and then later became partners at S16s with the same people who helped put that list together asking for the safe harbor for ETH. Furthermore, Deaton doubts Hyman's compliance with directions, alleging that his own SEC emails prove Hyman ignored that instruction and violated 18 U.C. 208(3) more times by meeting them. The allegations presented by Deaton are noteworthy, implying improper actions and relationships inside the SEC at the time of Ripple's lawsuit filing. As of the publication of this article, neither the SEC nor the parties implicated had issued any formal remarks in response to Deaton's charges. With the second deadline for the U.S. SEC's spot Bitcoin ETH set for the third week of October 2023, the focus is now on other important events affecting the crypto market. On September 27, 2023, at 10 a.m. Eastern Time, U.S. Securities and Exchange Commission Chair Gary Gensler is expected to testify before the House Financial Services Committee on the agency's supervision. Members of the committee have a history of vehemently opposing Gensler's ideas, particularly on the crypto regulatory framework. In an April 2023 hearing, Committee Chairman Patrick McKentry questioned the Commission Chair if Ethereum, ETH, was a security or a commodity. This might be a topic of discussion again at the forthcoming hearing in the context of the XRP lawsuit judgment, which classified token sales to regular customers as not securities. The Bureau of Economic Analysis is scheduled to issue the Personal Consumption Expenditures (PESI) price index data for August on September 29, 2023. Ripple will hold the proper party in New York City on September 29, 2023. It will be a communal celebration of liberation from legal difficulties as a result of the recent partial success in the SEC litigation. While the event has no direct influence on XRP demand and supply, it may have an effect on market mood. Furthermore, it is likely that the corporation would make no major announcements during the event. Participants in the cryptocurrency market have recently begun debating Ethereum Gate, which alludes to the U.S. Securities and Exchange Commission's SEC, purportedly favoring the Ethereum Foundation. With XRP attorney John Deaton admitting that he has seen papers relating to the alleged wrongdoings, it is thought that these revelations are just the beginning of a lengthy, drawn-out exposure. The discussion around Ethereum Gate heated up when Steven Nureyev, an early advisor at the Ethereum Foundation, said in a September 17, 2023, tweet that members at the foundation were concealing the true number of ETH purchasers during the cryptocurrency's 2014 initial coin offering, ISO. Previously, CoinGate revealed XRP lawyer John Deaton's disclosure that he has seen some of their seats that might reveal the truth about the ISO figure. While consenting to examine the data, the lawyer allegedly alluded to Ethereum when he said that he could not release the identities due to attorney-client privilege. This suggests Nureyev signed an engagement agreement with attorney Deaton. This may imply Deaton defending the former ETH advisor in court if necessary. Another attorney, Fred Rispoli, explained that the attorney-client privilege might have far-reaching consequences. He cautioned that the collaboration might have far-reaching consequences, predicting very big things to come. Is Nureyev suing the Ethereum Foundation over the framing of fraud charges? Attorney Deaton is well known for his belief that the U.S. SEC backed Ethereum while making the Ripple project a scapegoat in its legal efforts. As a result, a lawsuit on Nureyev's behalf might be filed in the coming months. Blockchain, the breakthrough technology powering cryptocurrencies, has prepared the path for a decentralized financial environment. However, the absence of a defined regulatory framework has often been a cause of friction between blockchain enthusiasts and regulatory organizations. A recent skirmish in this continuing war was observed when Ripple's chief legal officer, Stuart Alderodi, and XRP supporter, John E. Deaton, turned to social media to call out SEC chair Gary Gensler on his anti-crypto beliefs. Their claims followed Gensler's appearance on Bloomberg, in which he urged for the application of securities regulations to cryptocurrencies in order to avoid fraud and manipulation. The critique comes at an opportune moment, since the crypto sector, represented by companies like Ripple and Coinbase, has been aggressively pursuing regulatory clarification in the United States in order to stimulate innovation and investor protection. Alderodi emphasized Gensler's inconsistency, accusing him of ignoring court rulings and harming the drive for regulatory clarity. Deaton, on the other hand, expressed similar worries, underlining the necessity for investor protection against the SEC's anti-crypto stance and hypocrisy. The debate goes beyond words. Deaton, who represents a sizable number of XRP investors, is a powerful voice in the crypto legal sphere. The issue sparked more discussion in the crypto community, with Steven Nureyev, an early Ethereum advisor, remarking on the $19.02 trillion loss of U.S. family wealth during the housing crisis, which occurred under regulated institutions. He hints at irony by doubting the efficiency of legislation in protecting individuals against fraud and manipulation. Furthermore, Deaton plans to have Nureyev on crypto law to shed light on Ethereum's initial coin offering, IU poll, and potential SEC misconduct. In another layer of complication, federal courts have labeled the SEC's allegations in previous cases as arbitrary and capricious, with Judge Knepern in the Ripple case labeling the SEC's conflicting stances as disingenuous. The continuous legal and public debate shows the maze of regulatory uncertainty ensnaring the crypto business. Despite these heated discussions, the basic problem remains unaffected: the critical need for a fair and transparent regulatory framework that supports innovation while protecting investor interests in the quickly growing blockchain field. Attorney John Deaton, the creator of crypto Law Us, has dropped 3 indications about his much-anticipated big announcement, which he plans to make later today. For perspective, Deaton tweeted earlier this week that if all goes as planned, he would make a huge announcement tonight, September 22. The post left the XRP community in suspense, with many asking Attorney Deaton for indications that may help them prepare for the so-called big announcement. Notably, Deaton ultimately revealed 3 clues when Jungle Inc. 2.0, a renowned XRP fan, sought information about the launch. Can we get a hint on what the possible announcement tomorrow may be? John Deaton, the XRP enthusiast, inquired. In response, the pro-XRPier said that the major news relates around an image he linked to the tweet, the XRP, REU, XRP, or the ETHICO story. The first hint came in the form of an image showing Deaton scrutinizing some paperwork. Although the contents of the documents were not visible in the image, XRP aficionados suspect that the docs might be related to the current sexy UV Ripple litigation. If this is accurate, Deaton may be providing an important update on the case later today. Notably, Attorney Deaton is heavily involved in the action, acting as an amicus curiae for thousands of XRP holders. Deaton's role in the litigation helped to Ripple partial success against the SEC. Deaton's second clue suggested that the announcement may be regarding XRP. Notably, XRP is a decentralized public blockchain that is critical to the operation of the XRP currency. If Deaton's announcement is on the XRP, the crypto world may see him offer the most recent developments regarding the top blockchain technology. It is worth noting that Deaton does not typically remark on the technological element of XRP. His cryptocurrency-related tweets have largely focused on the SEC Ripple litigation. Recall that leading crypto stakeholders, including Deaton, recently participated in a big debate on the Ethereum ETH. This comes after Steven Nureyev, an early Ethereum advisor, raised concerns about possible SEC corruption before and after the ICO. Nureyev also claimed that Ethereum breached the rules of its ICO, claiming that it is impossible to determine the number of investors that took part in the event. Deaton said shortly after Nureyev's claim that he was working on putting the early Ethereum advisor on his Crypto Law TV program. Attorney Deaton is expected to announce later today that Nureyev will appear as a guest on the show's upcoming edition. Meanwhile, it is difficult to predict the specific contents of Deaton's momentous statement. Several XRP community members, however, have opted to sit back and wait for the top lawyer to make the major statement today, as promised.